Thank you. Please be seated. All right, we're on the record on this matter, State of Idaho versus Alan Douglas Bruce. Mr. Bruce is here present with his attorney, Mr. Archibald. Mr. Rogers appearing as prosecuting attorney for Custer County. Mr. Bruce, you previously appeared before the court and entered a plea of guilty as an Alford plea pursuant to a plea agreement to the amended charge of second-degree murder. You also entered a plea of guilty to count 2 of the amended information, charging you with destruction of evidence. The state dismissed the balance of the charges, including the persistent violator charge as part of the original charges in this case. The court accepted your plea of guilty and entered it in the record, and I set today for the time and place of sentencing on somewhat of an expedited basis. Typically takes a little longer than this to get a matter to sentencing because of the time needed to prepare a pre-sentence report. In this case, we did get an agreement with the probation office to expedite that process, and so we did receive a pre-sentence report in a fairly short time frame, and that was filed with the court on November 10th. And Mr. Archibald, Mr. Rogers, I assume you received your copies of that report, correct?
Yes, Your Honor. Yes, Your Honor.
Are you all prepared to proceed with sentencing today, Mr. Rogers?
Yes, Your Honor.
Mr. Archibald?
Your Honor, in reviewing the pre-sentence report with my client, I was able to get to Salmon to do that on Friday. So we reviewed the report together Friday night and Saturday morning, and my client would like to withdraw his plea. So I apologize to the court. I didn't have time to prepare and file a motion. So my client would like to be heard on withdrawing his plea and proceeding to trial.
All right. Well, counsel, I guess due to the status of this case, and we feel like we addressed that issue at the time Mr. Bruce entered his plea of guilty, that the process that I went through with him at that time and placed him under oath to ask him a number of questions regarding the entry of his plea, whether his plea was being freely and voluntarily entered, if he understood the terms of the plea agreement that were in place at that point in time, the rights that he was waiving to enter his plea, and really the timing of all of that with the trial. It was usually set at that time, was set for just the following week, I believe, to begin on November 4th, that we would have otherwise been proceeding to trial as he had been requesting, without waiving his right to a speedy trial. And I indicated to him that the difficulty it would be for him to change his mind and to withdraw his plea of guilty. And I believe I advised him at that point in time that the standard, since this is a plea agreement that's intended to be binding on the court, and so at the time he entered his plea, he was aware of what the sentence would be in this case if the court followed the plea agreement, that the standard would be for the court to apply in determining whether to allow a withdrawal of a plea would be, in my view, would be manifest injustice, which is a much higher standard and burden to meet to withdraw a plea of guilty under those circumstances. Now, I'm aware of the case law in the state of Idaho that says the court should look with favor, or maybe not those terms, but look with some leniency to allowing the withdrawal of a guilty plea. But I think the circumstances of this situation and the history over the last 2 or 3 months, where we have appeared twice really for entry of a plea, back at the end of September, where there's a similar situation where a plea agreement had been entered into after mediation, and we appeared in court and you advised the court that your client had changed his mind and no longer wished to enter a plea of guilty. And so we set the matter for trial at the week of November. It had already been set, back in July. We set the trial for the first week of November. Your client was requesting to be kept on that date. And so we did so, and everyone was preparing for trial. And then a week before trial, approximately, this new plea agreement was entered into, and your client entered a plea of guilty after a fairly lengthy discussion with the court under oath. So I'm not inclined to grant that request today, and I would intend to proceed forward with sentencing, and I guess it could be addressed at a later time, and you've made your record today, Mr. Archibald, what your client's desire is. Mr. Rogers, does the state wish to make a record or have any position on the matter?
Yes, thank you, Your Honor. I echo most of what the court says. I also, just to highlight that at the change of plea sentencing, the court did give notice of its intent to accept the plea agreement and was waiting for today to finish the sentencing on that. And I think what the court has addressed under Idaho Criminal Rule 11F, nothing has been warranted for a withdrawal of plea at this point, and I think the rule is sound on that along with the case law. So other than that, I would echo the court sentiment. I would ask for the court to deny the motion.
All right, so we're going to go ahead and proceed with sentencing today. Only reiterate what I did say at that change of plea hearing, is I did feel like we needed to recognize the victim's rights and the rights of the victim to have their input at the time of sentencing, and the court wanted to hear their comments, but I did indicate at that time that I was intending to accept the plea agreement, but wanted the victims to have a right to make their statements in court. So in any event, that's the order of the court, and we're going to go ahead and proceed with sentencing today, counsel. Obviously, you can proceed thereafter with whatever process you feel you need to take. And as I've already stated for the record, the rule provides that you must show a just reason for a withdrawal of the plea. That hasn't been shown to the court, and I would intend to proceed today. But I also think the higher standard applies of manifest injustice if you attempt to withdraw your plea of guilty after sentencing. And although sentencing has not occurred yet, it was understood what the sentence was going to be in this case when Mr. Bruce pled guilty. And so I think, in my opinion, that same manifest injustice standard should be applied. So in any event, we'll proceed with sentencing. So I guess, Mr. Archibald, are there any parts of the pre-sentence investigation that need to be clarified or corrected?
Yes. On page 1 of the pre-sentence investigation report, where it indicates that a DNA collection is needed, Mr. Bruce reported to me that he has already provided a DNA sample.
I mean, where is that reflected on not page 1?
Under the name, address, Lehigh County Jail.
I do see where you're referring there to. So that he's indicating he's already provided that?
Yes.
All right. Well, as far as correcting that or changing that, I'm going to leave that to the Department of Corrections to check their records. If he has already provided it, then he will not have to do it again. But if he has not, he would be required to do so. So I'm not going to change that particular entry.
And the criminal history is where there are a lot of corrections. So turning to page 12.
Give me just a minute to get there. All right, go ahead.
Mr. Bruce indicates that there must be another Alan Bruce in California because the Alan Bruce seated next to me says that he only has 2 prior felonies, not 5 prior felonies. And so going through this, the second charge listed from the start, where it indicates prior record, and the year starting in April of 2000, taking a vehicle without owner's consent, a felony. Mr. Bruce indicates no, that is not him. The next crime.
Give me just a moment, counsel. I'll make some notation to the precinct's report. I'll have you go through these. I'm sort of just trying to decide if I'm going to change or correct anything here, because I don't know, and I'll ask Mr. Rogers if he knows or not when we're finished whether these are accurate or Mr. Bruce's understanding of this record is mistaken, and so I have to kind of rely upon the records, the NCIC records, and to see what is there. But if something is not him, then that's going to have to be corrected. But I don't know if I'm in a position today to say yes, we're going to strike that one and remove it, because I don't know if that's really the case. But go ahead and go through your corrections you feel need to be made.
And that's what I indicated to Mr. Bruce, is that it wouldn't affect the sentence today because we already have an agreed upon sentence, but it could affect his conversations with the parole board.
And I understand that. I may just make a note here that Mr. Bruce disputes the accuracy of this prior record, and that the Department of Corrections should thoroughly check that and research it to ensure that they have an accurate picture of that prior record without going through each one piece by piece. So I will make that note, but you can go ahead and make your record.
And then the third crime listed on page 12, the carrying a concealed weapon, it says it was dismissed, but again, he says no, that was not him. The next charge in April of 2002, a battery with serious bodily injury, a felony. That charge was dismissed, but again, he said no, that was not him. The next charge in May of 2002, the bottom of page 12, battery with serious bodily injury. That charge was dismissed, but again, Mr. Bruce said no, that was not him. Going to page 13, the top of page 13, in December of 2002, carrying a concealed weapon, a felony. Mr. Bruce says no, that is not him. The third charge down from the top of the page on page 13, in March of 2005, Mr. Bruce indicates no, that is not him. A misdemeanor, being under the influence of a controlled substance. The next charge down, September of 2005, it says no